Officer Dade, would you open the courtroom, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge Davis Braxton Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning.
Morning, Your Honor.
Good morning, counsel. Had a little technical difficulty today, sorry. She was acting inappropriately. You guys are
I
7-4.
have two with you this morning, Your Honor. I think Mr. Boyke is on,
674.
what's that, Your Honor?
He's on 674.
674.
Is Oswald? Yeah.
Oswald, yes.
All right, let's call your claim. This is file number 221876674, Richard Oswald versus Progressive Michigan Insurance. Your respective appearances.
Yes, good morning, Your Honor. Connor Clardy, P84485, appearing on behalf of the plaintiff, Mr. Oswald.
Good morning, Your Honor. Charles Boyke, P77261, appearing on behalf of defendant.
All right, gentlemen, have we made our 2.3028 disclosures?
Disclosures have been made.
I still need to make mine, Your Honor. I believe I have about a week or so, but I will get them out.
How would you believe you have a week or so?
Let me check my file. I might have already done mine. I set to dos, and right when I clicked to see the timeline to do, it was gone. So I'm
looking at my order. Dated 5/25 says what's to be done within 21 days. So I'm having a little trouble understanding your last point.
Your Honor, I didn't know if I was in receipt of that order just yet.
That's what we're here today, counsel.
Oh, your scheduling order. Okay, I apologize. Then I will get mine out this week, Your Honor. I apologize for that delay.
All right, then I'll give you guys another date. Mr. Clardy, you're not anywhere near my jurisdictional max, are you?
That's as of today's date, it's just medical bills, Your Honor. Medical bills total approximately 17,000, which is exclusive of attorney costs and fees. Even with, even if we were to get attorney's costs and fees and the interest, it would still fall below the jurisdictional limit.
You're not going to have any other claims, is what I'm asking.
No, there's as far as I know, there is no wage loss, no replacement services.
And are you done with medical, or is medical ongoing?
No, medical is, as far as I know, it is not ongoing.
All right, then you apparently are going to be with me. Your next date, gentlemen, will be September 22nd at 10 o'clock. Does that work for everybody?
Yes, Your Honor.
Mr. Borky, let's read that order.
I will definitely make sure to read that order, Your Honor, and comply with it. I apologize.
All right, September 22nd at 10 o'clock, we'll try this again. And I'll note that the defendant is to make the disclosures. All right, gentlemen, what else we can accomplish today?
I'm sorry, Your Honor, I didn't hear you.
Sorry. Was there anything else we could accomplish today?
Not on this file, Your Honor.
No, thank you.
Mr. Borky, I'm going to release you there. Thank you.
Have a nice day.
You too, sir.
You too.
And Mr. Clardy has.
And I believe Miss Kennedy is defense counsel, although it's possible that someone's standing in for her today.
All right, let's see if we can find Miss Kennedy. I saw her here. Carrie Kennedy for Liberty Mutual.
Yes, Your Honor.
DH.
Hey, what do I need? I want.
Ms. Kennedy, unmute yourself.
Good morning, Your Honor.
Good morning. This is file number 22-187-988. Lavidia Hereford versus the Liberty Surplus Insurance Company. Your appearances.
Yes, good morning, Your Honor. Connor Clardy, P 4485, appearing on behalf of the plaintiff. Ms. Hereford.
And Carrie Kennedy, P52443, appearing on behalf of Liberty Mutual, or Liberty Surplus Insurance Company, excuse me.
A very strange name. First question is, have we made the 2.3028 disclosures as being our first pretrial?
Plaintiff has made their initial disclosures.
Ms. Kennedy?
Yes, Your Honor.
Okay. Mr. Clary, how much are we arguing about here?
Well, as I spoke with Ms. Kennedy or emailed with Ms. Kennedy this morning, it looks like as of right now, the total outstanding claim is $4,340 for replacement services. I am still trying to figure out if there are any liens, medical liens that maybe that need to be taken care of. So I'm not sure what the total overall claim is going to be at that point, but as of today's date, that's what we're showing as outstanding.
That within my jurisdictional max? Let's have you
Oh,
guys-
I don't think it's gonna go near 25, Your Honor.
Right. September 22nd at 10 o'clock will be our next pretrial. I know it works with Mr. Clardy. Does it work for you, Ms. Kennedy?
Yes, Your Honor. Nothing further for me, and I think we'll have this worked out by then.
Okay, we'll send you out an order, September 22nd at 10 o'clock. And I'll note for the record, both sides have made their disclosures. Thank you for coming.
Thank you, Your Honor. Have a great day, sir.
You too, sir.
Have a good day, Ms. Kennedy.
Thank you.
Be safe. Ms. Schwartz, good morning.
Good morning, Your Honor.
You've got Apps Care versus State Farm.
I do.
Okay, let's get Mr. Allen in here. We can get started.
Thank you.
I'm trying, Your Honor.
Okay.
There we go. Sorry about that. I
Hey,
kept
that's
pressing
all right.
button. Not successful.
I had to get IT in this morning. My machine just decided it wasn't working today. So sorry about that. This is case number 21164-260. Apps Care Pharmacy versus State Farm Mutual Automobile Insurance Company. Date and time for pretrial. Your respective appearances.
Good morning, Your Honor. Rachel Schwartz on behalf of the plaintiff ASB Cares P54947.
Good morning, Your Honor. Dan Allen on behalf of State Farm P71335.
Okay, first question. Have we made the 2.302A disclosures on both sides?
We have, Your Honor. I think we have, was under the impression we had two motions up for this morning as well.
No, I don't have anything else in the file today other than the notice of, I'm sorry.
I only have one motion.
Wait. This is,
Your I think 2 weeks ago, this motion was up and I was unavailable, so you were kind enough to adjourn it 2 weeks, if that helps at all.
I picked up the wrong file. That might be part of the problem. Okay. This is the State Farm's motion for partial summary disposition. That's it. Okay, and I see, I had to adjourn the matter the last time we were here.
Yes, I had sent my associate, but I guess by that time he had said that you guys were willing to adjourn it, so.
Yeah, and the other thing is that Mr. Allen, there is a massive motion on motion to eliminate. But since I'm not at the point where I'm worried about trial evidence, we'll deal with that if and when that necessity comes around. Let's do
Okay.
a motion for partial summary disposition today.
All right, so just so I can let the attorney of record know for that regarding the motion in limine, once we get to that point, do we just renotice it to be heard if we haven't resolved or got to that point yet?
Exactly right.
Okay. Let me just write that down because otherwise I will forget, Your Honor. Okay, then yes, Your Honor, I think then the only matter that remains pending is the motion for summary disposition, partial summary disposition.
Partial summary disposition. And it is your motion, if you would, sir.
Yes, so Your Honor, I think it's actually a pretty a simple motion, at least as to the facts go. Basically, State Farm is arguing that both parties are subject to a third-party network agreement through Prime Health. Plaintiff agrees to that. State Farm, in their response, plaintiff agrees to that. State Farm asserts that related to the services in question and from the correspondences from Prime Health, the third-party administrator of that agreement, that the amount in controversy or the amount of damages that should be collected should be capped at $653.93, and that is what they've asserted for the dates of services in question. Plaintiff, on the other hand, argues that that's a question of fact, and that at a minimum, it should be capped at 75% of the amount charged. However, plaintiff hasn't provided anything in response to refute what the Prime Health Services has indicated would be payable under the contract. Accordingly, it State Farm's position then that that's what damages should be capped at.
Ms. Schwartz.
Yes, Your Honor. This case involved two different dates of service. One date of service is in question, that's August 12th, 2020. Plaintiff does agree that they're subjected to the contractual arrangement with Premier, I'm sorry. And we don't contest that. The issue at hand is whether or not the contract says it gives three options, that the plaintiff will receive the lesser of the following: 75% of the submitted bill charges, 120% of a current Medicare fee schedule, or 85% of the maximum allowable rate under federal state fee schedule. It's not clear to me how defendant has come to the amount. They have arrived at 653.93. Our contention is that Medicare does not have a fee schedule with regard to this service.
All
Neither
right, so that's not relevant.
Right. The state at the time on August 12th, 2020 did not have a fee schedule. So by my calculation,
Doesn't that leave us then at the 75%?
that's what I see.
If there are three possibilities and you can see two of them don't apply.
So I will say that there was an affidavit submitted by Michelle Hill from Prime Health Services. And what she does say is that, or it wasn't an affidavit, it was a letter,
Oh.
assuming the client applied the correct fee schedule, our records indicate the bill for the would be this 653. Well, she prefaced it by saying the correct fee schedule, and clearly they didn't apply the correct fee schedule. So I'm not understanding where they even got to that number. I mean, no fee
Let me stop you
schedule.
right there. How do you conclude they did not apply the correct fee schedule when you can see that two out of the three possibilities are not applicable here? The Medicaid adjustment and the other, the state, which you say are not applicable. I'm confused.
Okay, well, the bill was for an amount of 8,000.
No, it's 90/20, 92/76/30.
Thank you, Honor. So 75% of that is far in excess of the 653. So I'm not understanding where defendant, agrees that it's at the very least, it's a question of fact. I think it's a question of law that you can decide that 75% is the number that should be applied to the $9,000 bill. And therefore it's far in excess of what I think the number would be $77,143.46 that would be obligated to pay that I set forth in my motion.
But you have a $248.28 bill as well, correct?
I think that's the one that's not subjected to that at the time of the that was incurred, that there was no contract in place with Premier. So
Well,
that one's not in consideration.
The services that were rendered on August 12th, you can see were in the contract with Prime, correct?
We do concede that, yes.
And then the services that were rendered the following month, you say were not in the contract?
True, Your Honor. The contract expired and it was not renewed.
All right, let me hear from Mr. Allen.
While it's on the top of my mind, the affidavit from Prime Health Services, which is also attached, indicates that the agreement is termed effective November 18th of 2020. So it would seem that second date is applicable.
Outside.
Yeah, it seems like that second date would apply, because I think that was September of 2020. We have 2 dates of service, August of 2020, one is September of 2020.
Yes.
The affidavit shows that the contract was to terminate in November of 2020.
So it was live at the time of both services, okay?
Yes, that's how I would read that. As to plaintiff's position in regards to how Prime Health calculated, again, I would say that this is how the third-party administrator who coordinates this agreement between the two parties calculated what would be due and owing. And I will correct myself. It looks like they were only opining as to the August 12th of 2020 date of service.
If I could interject, just I think the second date of service is September 11th, 2020, according to your brief, just for clarification.
And the agreement was good until November, both dates being inside the viable portion of the agreement.
That's
So,
not,
Mr.
okay.
Allen, what you're saying is that the affidavit that you provided from Prime Health speaks only to the 9/2/76/30 services on August 12th.
That would appear so, Your Honor, from from the way it is written, yes.
Okay, is there anything else you want to say?
Well, yes, Your Honor, so the calculations it says, assuming the client applied the correct fee schedule, and then it goes on to indicate what the final allowance should be for plaintiff in this matter. The fact of the matter is State Farm denied these based upon a wholly separate reason, that they were unrelated to the subject accident. So that first clause that is really inapplicable, because there was no fee schedule that State Farm applied anyway. because it was denying the benefits based upon something else. So what the base of this motion is saying, look, even if these are found that to be reasonably necessary for the care such that they're compensable under the act, plaintiff is still confined by the terms of the agreement. And Prime Health
on the dollar. In essence.
Pardon?
Basically, your argument is this: we're not conceding that these are reasonable and necessary charges. But if they are in fact reasonable and necessary and related to the automobile accident, we only pay 75 cents on the dollar.
Well, that's what plaintiff is arguing. We are arguing that what Prime Health has said is compensable for that August 12th date is what is compensable. That is what they have determined under the contract to be the rate.
Well, the problem, I'm sorry, the problem that I have is that the contract says, unless you are telling me that one of the exceptions other than the 75% rule is applicable, that is the Michigan rule or the Medicaid rule, the contract says 75%.
Well, Your Honor, I don't believe that it's accurate to say that Medicare, if I'm correct, I believe Medicare Part B provides for payment of prescriptions. So to say that Medicare is not an applicable consideration, I don't think is correct at this point. As far as the fee schedule, I don't think that is also restricted to the fee schedule that we know went into effect on July 1st of 2021 related to the No Fault Act. Notwithstanding, I can't say with any certainty to the court of another fee schedule that would apply. So,
but this is what I'm going to do. Thank you both. I don't have an affidavit from Ms. Hill. I have it to whom it may concern. C10 motions shall be supported by affidavits, not letters. So what I'm going to do in the absence of this, that I'm going to simply deny the motion. The denial is without prejudice. If you want to move forward and comply with the rule with an affidavit, as distinguished from a to whom it may concern, I'll consider that at the time. But at this point in time, your motion does not comply with with the requirements of C10 because there's no affidavit to it. It's a to whom it may concern letter. And that could be anything.
I understand, Your Honor. Then if I may suggest, can we, and maybe it would help move the parties forward. And I think it's at least something that is agreed upon in the motion and in the response, is a finding that the agreement, the Prime Health Services agreement does apply, and that at a minimum, the 75% provision applies. And then if we want to bring the motion to say, no, that is incorrect, that there is a Medicare Part B, then we can re-raise that motion in summary disposition.
What I'm going to do is I'm simply going to deny the motion.
Okay. Very well, Your Honor.
And if you want to submit between the two of you a stipulation in regard to number one, the prime agreement is in effect. Number two, the rate to be applied under the prime agreement is XYZ, then so be it. But right now, what I have is your statement to whom it may concern from Prime, and I have Ms. Schwartz's statements. So we really don't have a basis to form to make a determination of a genuine issue of material fact or lack thereof under the court rule, since I'm not supported by affidavit anywhere. So the order today will be that the motion for partial summary disposition is denied without prejudice.
Can I ask just that if defense does move forward with this and gets an affidavit, that they just have this dispute resolution person explain how she calculates these numbers, so that, I mean, we're willing to look at it if there's some explanation, but based on what I see, it's just not possible.
Well, at this point, I'm sure counsel can do whatever it is he decides he wants to do.
Okay.
But at this point, the decision before me is limited to the decision that I've made in regard to the motion for partial summary disposition. As I indicated in regard to the other motions, I'm simply not setting a date for that because I don't know whether or not we're going to actually get to the point where a motion eliminate, which is only relevant for in preparation for trial is going to be something that we need to talk about one way or the other.
Perfect.
So what I'm going to do today is I'm going to send out an order denying the motion for partial summary disposition without prejudice for the reasons set forth on the record. I'm going to give you guys a return pretrial date. And that's going to be September 22nd at 10 o'clock. Then if the defendant wishes to file another motion for partial summary disposition in compliance with the court rules supported by an affidavit, as distinguished from to whom it may concern. I'm not yet familiar with that as being substitute for that affidavit.
Your
We'll
Honor,
look at if and when it comes up. Ms. Schwartz.
is there any day, can we do a different day? I have depositions the morning and artery, a doctor appointment at
Sure.
noon at U of M.
Sure.
Yes.
September 23rd. Does that work for everybody?
Sure.
Let
Mr.
me,
Allen?
I can't speak for Mr. Bates, Your Honor, but let me just look at mine, and if he is unavailable, I will certainly, I am available that date if he is not.
All right, then let me write it down now, September 23rd. At 10 a.m. Set the file for pretrial.
Thank you, Your Honor. I appreciate it.
No problem.
And Your Honor, if I may, just to clear a record, because I don't know how my client will want to proceed, that there is an affidavit attached to the motion in addition to the letter, which I know that the court has reviewed, but I just wanted to make that part of the record that there is something there
I
that
agree.
acknowledges the agreement. And
But my reading of the affidavit basically is that it is what you guys have agreed on, that the agreement was in fact in effect. So that's not helpful to me on the real question is, what is the rate to be applied?
thank you, Your Honor. I appreciate the clarification with that.
So if September 23rd at 10 a.m., we'll try this again.
Thank you so much. Have a good day.
And just against you, when you report to your client, the court declined to set a date for hearing for your motion to eliminate until we get to the point where we're approaching trial.
Okay. Yes, I'll let them know, and I'll let Mr. Bates know as well that we can discuss that on the 23rd of September as well if needed.
We're not, I don't see us being anywhere near trial.
Correct.
That's the real issue.
Yeah.
And
I'm hopeful we can resolve it, but we'll see.
Well, we always are hopeful. And
Always.
I can't quite frankly remember the last time I actually tried a PIP case. They always seem to go away. But, we'll see that. We'll get to that when we get to it, okay?
All
Thank
right.
you.
All right. Thank
Thank
you
you very
for
much,
coming.
Senator. Have a great day, everybody.
All right, let's be safe. Thank you for coming in.
Judge, how are you?
Mr. Rusin, how are you today?
Oh, just living the dream every minute.
We are on the record. This is case number 22187-694. The file is entitled Credit Acceptance versus Gerald Montgomery or Jarrell Montgomery. This matter is set for pretrial today on an adjourned date. We were last together on July 7th, 2022, at which time the parties and counsel agreed to today's date, August 25th at 10 o'clock for our next pretrial. It's now after 10:30. Could I have your appearance, sir?
Judge, may it please the court, my name is Attorney Richard Grusin. I am the attorney of record for the plaintiff on bar number 35222.
All right, Mr. Montgomery has failed to appear. No good cause for that failure having been shown. The default of the defendant is hereby entered. We'll send you out a notice today, sir.
Thank you, Judge.
Thank
And
you.
on that, I rest.
All right.
All right, thank you, Judge.
Thank you. Morning, counsel. What brings you here today?
Good morning, Your Honor. William Beaumont Hospital v. Torrey Coleman.
Okay. I would have called this case some time ago, but you have the wrong case number on your screen.
I do. When I connect through your court, for some reason, it won't let me change. So it's probably a hearing about 3 days ago.
All right, let's call the file. We are on the record. This is case number 2218544, William Beaumont Hospital versus Torrey Coleman. Could I have your respective appearances?
Good morning, Your Honor. Joe Sapersky on behalf of William Beaumont Hospital, P63844.
And what is your name, sir?
Torrey Coleman, Your Honor.
Is it your intention to represent yourself in this matter?
Yes, sir.
Sir, you have an absolute constitutional right to do that. What you do not have is to write your own set of rules of civil procedure, your own rules of evidence, and your own statutes. If you elect to represent yourself, as is your constitutional right, the same rules that bind counsel will bind you as well. You understand that?
Yes, Your Honor.
Okay. Gentlemen, where are we on this file?
Your Honor, we have not had a chance to speak about the matter. In response to receiving Mr. Coleman's answer, I did forward to him at his address on Prince Hall Drive a complete itemization of the services that plaintiff is seeking in the lawsuit. Those do reflect that these are balances after insurance and our copays and deductibles.
All right, Mr. Coleman, you received that information?
Yes, Your Honor, I believe I did.
All right. Then what I'm going to do is I'm going to open your written discovery. I will give you gentlemen a new date. Then I'll give you time in the chat room, see if you can resolve the matter, since you now seem to have the same basic information. Does September 22nd, which is a Thursday like today, at 10 o'clock, does that work for both of you?
It does for plaintiff, Judge.
Same for me, Your Honor.
Okay. Your written discovery is now open. All right, is there anything else we could accomplish today? All right, let me put you gentlemen in the chat room. If you're able to settle the case, come back to me. If you don't, we'll talk again September 22nd at 10 o'clock in the morning.
Very good. Thank you, Judge.
Okay, now let's see if I can make the
Thank you.
technology work. Spersky, signed to room 2. Mr. Coleman, signed to room 2. Okay, seems to be it. We are on the record. We are calling file number 221800608. The file is entitled Beaumont Health versus Von Joe Rambus. By a notice dated July 28th, 2022, this matter is set for hearing today at 10 o'clock on the plaintiff's motion for entry of default judgment. Note for the record that on June 30th, 2022, the default of the defendant was entered. This matter was scheduled for hearing today, as I indicated, at 10 o'clock today. It's now 10:47. Neither party has appeared. The motion for default judgment will therefore be denied. We're off the record.
Alex Mendelssohn's first number. Symphony writing experience. Very simple, so it's in shape. His big sister Fanny's birthday. Most people just do that. Mid-80s better than today. So he has to take a family. Support for WRC is provided by the chapter of the American Board. It was founded
Morning, Your Honor.
We are on the record. Good morning. 00132694, Landmark Mortgage Services versus Garrett Littleton. This is a request for reconsideration. The court's denial of a default against garnishee defendant MKS Commercial Services LLC. Your appearance.
Scott Mancinelli for the moving party LMS,
Bar number.
P60148.
Your motion.
My motion is to revise this order because I think there must have been a confusion regarding the nature of the garnishment. This was a non-periodic garnishment to a closely held corporation owned by the defendant, who I have since spoke to on the phone several times. He knows about it. I've updated the service address. He got a copy of this motion. I since got records showing that this business does quite a bit of business. He's contracted out, does various commercial cleaning and things like that. And he uses that business bank account for that business for personal expenses. So this is the best way to collect on this very old judgment.
Why the delay?
The delay in what? In
You in your motion, sir, you said that you served the garnishment back in May 22nd of 2020. Your request for default came in more than 2 years later.
That's true.
Meantime, you had renewed the judgment back in July of 21.
The delay is probably due to COVID staffing issues when everybody went home in the spring of 2020 and everybody's working remotely and courts are not processing things. And frankly, it just didn't get scheduled. A follow-up did not get scheduled after this guy got personally served. So when I went to look through the file again, after talking to him personally and discussing, doing some payment plans, I was reminded, oh my God, I've got this garnishment here that was personally served. And he's done nothing about it. I then called him again and said, hey, what do you want to do here? I'm going to submit a judgment on this garnishment. Well, I don't think I should pay anything. So that's why I don't think there's any prejudice to the defendant. He was personally served and he's had notice of all this. And frankly, he's had a couple of years of no collection on his entity. So he's benefited by the delay, really. And if he had an issue with it, he could be here today.
Well, let me ask you this. Let us suppose, for purposes of our discussion, that the court had exercised its discretion and said, I'm not going to grant this default because you didn't do anything on it for 2 years. Would that have been within my discretion?
I suppose. I mean, if someone raised it, but no one raised that issue, and the default has been served on the opposing counsel, the opposing party, and he knows about it. There's no timeline in the garnishment court rule, MCR 3.101, as to when that has to be done.
The lack of timeliness is you can see is a reasonable ground for a court to say, I'm not going to do it. And that's where we are here.
All right, but that's not the reason in the order.
I think in this case, the court did commit an error because I read the garnishment incorrectly as a periodic when it was a non-periodic garnishment. So despite the fact that the court would be within its discretion to deny this on the basis of lack of timeliness, I am going to grant your motion for reconsideration. Send me in a new order for the default of the garnishee defendant on your non-periodic garnishment.
Okay. You want that via email or via 7-day rule, or how would you like?
7-day rule would be more appropriate.
Thank you, Your Honor. I will get it done.
Serve a copy to the other side.
Okay.
Thank
Very
you.
good. Thank you.
Be
Bye.
safe. That's going to conclude the morning call.